58 of 2026, and the Zambia Wildlife Amendment Bill, National Assembly Bill number 49 of 2026.
The Zambia National Public Health Institute Amendment Bill, National Assembly Bill number 50 of 2026 will also come up. The Medicines and Allied Substances Amendment Bill, National Assembly Bill number 51 of 2026 will also be considered. Not forgetting the Sports Council of Zambia Amendment Bill, National Assembly Bill number 52 of 2026, including the Zambia Educational Publishing House Foundation Amendment Bill, National Assembly Bill number 54 of 2026.
Others are the Zambia Institute of Advanced Legal Education Amendment Bill, National Assembly Bill number 56 of 2026, the Zambia Revenue Authority Amendment Bill, National Assembly Bill number 57 of 2026, the Tourism and Hospitality Amendment Bill, National Assembly Bill number 58 of 2026, the National Health Research Amendment Bill, National Assembly Bill number 59 of 2026, the National Institute of Public Administration, National Institute of Public Administration Amendment Bill, National Assembly Bill number 60 of 2026.
And the last few bills that will be considered will include the National Prosecution Authority Amendment Bill, National Assembly Bill number 61 of 2026, the Persons with Disabilities Amendment Bill, National Assembly Bill number 64 of 2026, the Land Perpetual Succession Bill, National Assembly Bill number 66 of 2026, and the National Pension Scheme Bill, National Assembly Bill number 68 of 2026. However, committee consideration of bills at committee stage is not the last orders. We still have two more bills. At which stage, Pauline?
These are at report stage. We have the Closed Circuit Television Public Protection Bill, National Assembly Bill number 1 of 2025, to be considered at committee stage, and the Land Survey Amendment Bill, National Assembly Bill number 12 of 2026, also to be considered at report stage. So these are the bills that are coming for consideration this evening as the House continues looking at business that is yet to be concluded before the House is adjourned sine die tomorrow, Tuesday, 12th May 2026. Of course, you will recall that on 30th April 2026, our Honor, the Vice President, moved a motion to suspend Standing Orders 24, 1 and 2, 27, 34, and 123 of the National Assembly of Zambia Standing Orders 2024 to enable the House to sit from Monday 4th to Tuesday 12th May 2026 from 10 hours until business is concluded on each day, as well as consider more than one stage of a bill at a single sitting until the House adjourns. And this was also to facilitate for the House to finish all the business that was outstanding. So the House has been sitting non-stop from Monday 4th May until tomorrow when the House concludes its business.
Yes, indeed, Pauline, and it's been it's been work. Let's just say it's been work.
Yes.
But of course, we're here to bring Parliament closer to you as Parliament TV. And just to mention that you can follow the deliberations on the DSTV platform. That's on channel 272. Then on GoTV platform, you can follow us on channel 28. And the Top Star platform, you can follow Parliament TV on channel 5. And in case you've just tuned in, like always, we do say that we appreciate your viewership and we hope that you'll be with us up to the time that we end today's transmission. But just a quick business did commence at 14 hours. The House resolved into Committee of the Whole House to consider supplementary estimates of expenditure number 1 of 2026, and the committee has since agreed to a total of about 26,320,696,581 kwacha. And after this, the presiding officer, Madam Speaker, did indeed nominate the Minister of Finance, the National Planning Committee of 1 to introduce the necessary legislation, and the Minister of Finance did present actually the Supplementary Appropriation Bill, National Assembly Bill number 78 of 2026. We do expect second reading to take place when business commences. In the meantime, enjoy watching Parliament TV.
Order, honorable members. When business was suspended, the House was considering the supplementary estimates of expenditure, number 1 of 2026, and the Honorable Minister of Finance and National Planning had just presented the Supplementary Appropriation Bill number, National Assembly Bill number 78 of 2026. Let the bill be read the first time.
The Supplementary Appropriation Bill, National Assembly Bill number 78 of 2026.
Day for second reading.
Now, Madam Speaker.
Second reading of the bill to be taken now. The Honorable Minister of Finance and National Planning.
Madam, I beg to move that the bill be now read a second time.
The question is that the bill be now read a second time. Any debate? The Honorable Minister of Finance and National Planning.
Madam Speaker, the House has just agreed to the supplementary estimates number 1 of 2026, and this bill is necessary to give effect to the resolution of this House. The supplementary estimates amounting to 26.3 billion kwacha seek to address critical expenditure pressures across key sectors of the economy. Notable allocations include substantial funding to the agricultural sector to support payments to farmers and agro-dealers under the Farmer Input Support Program. Firstly, resources under loans and investments to cater for wage adjustments, dismantling of arrears, and contingency provisions, as well as increased allocation to social protection programs such as social cash transfer and food security pack. Madam Speaker, additional provisions have also been made for electoral operations, mining sector development, and external debt service obligations. Notably, the supplementary estimates have been presented at a time when government is advancing the implementation of its external debt restructuring program, with significant progress made in securing debt treatment agreements. Madam, the estimates further reflect efforts to sustain macroeconomic stability, meet evolving fiscal obligations, and support key sectors amidst both domestic and external pressures, while ensuring continued delivery of essential public services and social protection interventions. Madam Speaker, I thank you.
Thank you very much. The question is that the bill be now read a second time. Any further debate? I see none. The Honorable Minister of Finance and National Planning, winding up debate.
Madam Speaker, I want to thank the House for the overwhelming support.
I put the question. The question is that the bill be now read a second time. As many as are of that opinion say aye. Aye. Of the contrary say no. The ayes have it. The question is resolved in the affirmative. Let the bill be read a second time.
The Supplementary Appropriation Bill, National Assembly Bill number 78 of 2026.
Committee stage to be taken when?
Now, Madam Speaker.
Committee stage to be taken now.
The House will now resolve into committee.
The Supplementary Appropriation Bill, National Assembly Bill number 78 of 2026. Clause 1, short title, any debate and objection. Clause 1 is agreed to. Clause 2, supplementary appropriation, any debate and objection. Clause 2 is agreed to. Schedule on pages 4, any debate and objection. Schedule on page 4 is agreed to. Schedule on pages 5, any debate and objection. Schedule on pages 5 is agreed to. Schedule on pages 6, any debate and objection. Schedule on pages 6 is agreed to. Schedule on page 7, any debate and objection. Schedule on page 7 is agreed to. Long title, any debate and objection. Long title is agreed to. The bill will be reported to the House as having passed through the committee without amendment. Madam, I have to report to the House that the Committee of the whole House has gone through the Supplementary Appropriation Bill, National Assembly Bill number 78 of 2026, without amendment.
Day for third reading.
Now, Madam Speaker.
Third reading to be taken now. The Honorable Minister of Finance and National Planning.
Madam Speaker, I beg to move that the bill be now read third time.
The question is that the bill be now read the third time. Any debate? Any objection? The question is agreed to. Let the bill be read the third time.
The Supplementary Appropriation Bill, National Assembly Bill number 78 of 2026.
Thank you. Next order.
The Benefits of Former Chief Justice Bill, National Assembly Bill number 67 of 2026, second reading.
The Honorable Acting Minister of Justice.
Madam Speaker, the Retirement Benefits of Former Chief Justice Bill 2026 seeks to provide for a standalone and comprehensive legal framework on the retirement benefits of a former Chief Justice that will ensure the integrity, independence, and efficiency of the judiciary.
Sorry, Honorable Minister, we will move the motion first.
Madam Speaker, I beg to move that the bill be now read a second time.
Thank you. The question is that the bill be now read the second time. Any debate? The Honorable Acting Minister of Justice. No.
Thank you, Madam Speaker. Madam Speaker, the Retirement Benefits of Former Chief Justice 2026 seeks to provide for a standalone and comprehensive legal framework on the retirement benefits of a former Chief Justice that will ensure the integrity, independence, and efficiency of the judiciary. Madam Speaker, in the Republic, the head of each of the three arms of government, that is the executive, the legislature, and the judiciary, perform distinct constitutional functions and bear significant responsibility in the governance of the Republic. Madam Speaker, currently the benefits of former President's Act, Cap 15 of the laws of Zambia, and the National Assembly Speaker's Retirement Benefits Act, Cap 130 of the laws of Zambia, provide for the retirement benefits of a former Republican President and Speaker, respectively. However, there is no standalone legislation providing for the retirement benefits of a former Chief Justice. Madam Speaker, this omission does not reflect the unique status and responsibilities of the office of the Chief Justice as head of an arm of government and creates inconsistency in the treatment of the heads of the three arms of government on the statute book. It is therefore necessary to introduce the benefits of former Chief Justice Bill 2026 in order to ensure consistency and adequately provide for the retirement benefits of a former Chief Justice as head of the judiciary. Madam Speaker, the bill once enacted will attract highly experienced legal practitioners to the bench, enhance the pool of candidates eligible for elevation, safeguard the office from corruption or external influence through adequate provision of benefits, and uphold public confidence in the judiciary and the rule of law. Madam Speaker, this bill is very progressive, and I therefore urge the honorable members of this august House to wholeheartedly support it. Madam Speaker, I beg to move.
Thank you very much. Any further debates? The Honorable Member for Nkana. Oh, sorry. The Chairperson of the Committee on Legislation and International Agreements, Honorable Member for Chitambo.
Thank you very much, Madam Speaker. I have the honor, on behalf of the Committee on Legislation and International Agreements, to present the report on the benefits of former Chief Justice, Bill number 67 of 2026, for the 5th session of the 13th National Assembly. Madam Speaker, the bill before this august House seeks to establish legislation governing the retirement benefits of a former Chief Justice currently. Matters relating to the retirement benefits of judges, including the Chief Justice, are provided for under the Judges' Conditions of Service Act, Chapter 277 of the laws of Zambia. However, stakeholders submitted and the committee agrees that the office of the Chief Justice occupies a unique constitutional position as the head of the judiciary and therefore warrants specific legislative recognition. Madam Speaker, the committee notes that judicial independence is one of the cornerstones of constitutional democracy. The Constitution vests judicial authority in the courts and safeguards the independence of the judiciary from undue influence or interference in this regard. Stakeholders emphasize that adequate retirement benefits form part of the broader protections intended to preserve the dignity, independence, and integrity of judicial office, even after retirement. Madam Speaker, the committee further observes that the bill seeks to align the retirement status of a former Chief Justice with that of other heads of arms of government, such as the Republican President and the Speaker of the National Assembly. Stakeholders generally supported this approach and viewed it as progressive and consistent with comparative practice in other jurisdictions. However, Madam Speaker, while supporting the enactment of the bill, the committee identified several areas requiring refinement in order to ensure constitutional alignment, fairness, and legal clarity. Madam Speaker, the committee observes with concern that Clause 2 relating to application limited the Act to individuals serving as Chief Justice from the date of commencement and does not apply to people who were already Chief Justice before the Act comes into effect. In this regard, the committee recommends the amendment of Clause 2 to extend the bill to all former Chief Justices. Madam Speaker, the committee notes that Clause 6, 1c, refers to removal from office on grounds of misconduct, whereas Article 143 of the Constitution refers to gross misconduct and also includes incompetence as a ground for removal of a judge. The committee therefore recommends that the clause be redrafted to align fully with the Constitution by replacing the term misconduct and replace it with gross misconduct and incompetence as an additional ground. Madam Speaker, the committee also considered the proposal that all benefits should automatically cease where a former Chief Justice is removed from office on 40-based grounds. While acknowledging the need for accountability in public office, the committee is of the view that a complete forfeiture of all benefits may be excessive, particularly where some benefits are earned through years of service rendered to the nation. Accordingly, the committee recommends that the bill adopts a more balanced approach similar to that provided under the Judges' Conditions of Service Act, where benefits may be reduced or certain additional privileges suspended, rather than imposing an absolute loss of all entitlements. Madam Speaker, the committee further observed concerns regarding the provision that disqualifies a former Chief Justice from benefits upon engaging in active politics. Stakeholders argued that once retired, a former Chief Justice ceases to perform judicial functions and remains entitled to enjoy constitutional freedoms, including freedom of association and participation in public affairs. The committee agrees with the position and therefore recommends the removal of active politics as a ground for loss of benefits. However, the committee further recommends that state-provided ancillary benefits should not be used for partisan political activities. Madam Speaker, the committee also took note of concerns regarding the fiscal implications of the bill, particularly in light of the country's broader socio-economic challenges. However, other stakeholders submitted that the number of potential beneficiaries remains limited and predictable, and therefore manageable within the national budget framework. Madam Speaker, in conclusion, the committee supports the enactment of the benefits of former Chief Justice, Bill number 67 of 2026, as it represents an important step towards strengthening the institutional dignity and independence of the judiciary. Nevertheless, the committee strongly urges the executive to consider the recommendations contained in the report in order to enhance the clarity, constitutionality, and fairness of the proposed law. Madam Speaker, I thank you.
Thank you. Any further debate? The Honorable Member for Shwangandu.
Thank you so much, Madam Speaker, for permitting me to make a few comments on the proposed amendments which intend to introduce a standalone piece of legislation to deal with conditions of former Chief Justices. Madam Speaker, as I support the proposed amendment, I just want to make a few comments to the effect that we should start being inclusive when we are dealing with matters of this nature. And like the mover of the motion has stated, previously the conditions of former Chief Justices were provided for in the Judges' Conditions of Service, Cap 277 of the laws of Zambia. So to just isolate one office without reviewing the rest of the other offices poses a challenge. Yes, we know the financial implications that come with such improvements, but indeed, if we have to honor people that serve at that high level of the arm of government, being the judiciary, we must just strive to find resources. Now, I'm emphasizing the point of inclusivity. If you look at those who hold the office of the Vice, the Deputy Chief Justice, some of them would hold that office up to retirement. And yet, they more often than not also perform the same duties as the Chief Justice in their absence. So why should we leave out such important office orders when we are catering for the top for the top position? And this brings to my mind the consideration of the President of the Constitutional Court, which is also the court, a standalone kind of independent court with the President. What then happens to those that superintend over such an important court? So when we have got an opportunity like this, Madam Speaker, it's important that we bring pieces of legislation that are inclusive so that we don't leave people out. Because, you know, it's like a parent just looking after the parent without taking care of the children. So, in my view, we must be inclusive. We should have been looking at the improvements on the judges and the conditions of judges under the Act which was providing for the Chief Justice. So that as you are improving at the top, consequently, you are also considering those that are bottom. That way, you are holistic, you are taking care of everybody. And not that you give them the same and exact conditions, but you must be seen to be caring for all those constitutional officers who are under the judiciary. And like I've said, the next thing we shall be saying, what about the President of the Constitutional Court? Then you start thinking of bringing another piece of legislation. So, Madam Speaker, for me, my considered view that even as much as we are finalizing this bill, it's not too late that the sponsor of the bill can relook at some of those considerations that caters for others. We have had people that have served as deputy Chief Justice eminently, for a long period of time, including swearing in presidents as acting Chief Justices. So, to try and leave them out here is being unfair, Madam Speaker. So, as we are passing this bill for the second reading, my earnest appeal to the sponsors of the bill is to make those considerations. This is how we left the office of the Vice President, Madam Speaker. After we enacted the Constitution in 2016, we were supposed to consequently revise the conditions of the Vice President. I'm happy that we have attended to that just recently. But it shouldn't be the case. We should have done it immediately after the 2016 Constitution was done. So this is the same thing I'm appealing here. We shouldn't just, yes, we agree the Chief Justice needs to be looked after, but there are others too. The judges who retire, how do we also consider them by improving some of the conditions in the act that governs their conditions of service? Lastly, Madam Speaker, I don't know why these issues of saying the spouse, surviving spouses has been such an issue, and now we fail to deal with simple, straightforward these issues like this. Because at the end of the day, the drama will still be there if we don't provide for those issues in the law. Yes, indeed, there are certain traditions where it's normal for people to have more than one wife. There are traditions, we can't avoid that. There are traditions which cater for which permits, and it's normal. There are people, I don't just want to be segregative by naming the regions, but there are cultures that allow people to marry two wives. What do you do to these people when there are succession issues that now go to benefits? So we should just bite the bullet, Madam Speaker, and address those issues because they are there in communities. I remember my old honorable member, the late, may so rest in peace, Honorable Muntanga, here, the elephant, used to tell us here, and I remember his debate, he could say, look, don't demonize those people who openly marry two women because the culture accommodates them. And then he was challenging some members, I remember at some point, and says, oh, but you have got 3 hidden ones. So these are realities of life, Madam Speaker, but that we need to start dealing with when we are providing for pieces of legislation governing people's offices. Madam Speaker, with these few remarks, I support the bill, but I also press it on record that the sponsors of the bill must take into account the other very important offices that go alongside the Chief Justice. The Deputy Chief Justice, the President of the Constitutional Court should be considered as we pass this piece of legislation. Madam Speaker, I thank you.
Thank you very much. The Honorable Member for Nkana.
Madam Speaker, let me start by stating that I'm very reluctant to support this proposal. As usual, I take reservations in supporting laws that have got a lot of ambiguities, and lacks a lot of clarities in provisions that are suggested. Just as an example, Madam Speaker, when we were passing the law relating to the entitlements of the former vice president, we had provided for even those that served in prior years. But here, this law is specific to the Chief Justice at the time of the consideration of this particular proposal. So, like my elder brother, I am reluctant to support a law that targets individuals. I am also reluctant because of the clarity in that when the law speaks to a surviving spouse and only names a child, just like Honorable Kampyongo was saying, there will be cases where somebody would survive, or four or 3 or more spouses will survive after the Chief Justice. What happens to how we deal with all these surviving, spouses? Now, I am compelled to express reservations because of what has been noted by many stakeholders, the fiscal and budgetary implication of this proposal. Madam Speaker, this law is proposing for the establishment of very expensive, benefits for a Chief Justice. We are being told of a tax-free salary, and this is for life. We are being told of a mansion that has to be built, a car, and the government will have to take care of a driver as well as servicing. Now, this speaks to priorities. At a time like this, Madam Speaker, when overall the resource envelope for government seems to be thinning every day, I think for me it's erroneous to continue prioritizing, paying off very senior government officials at the expense of the many citizens who are needing government support. Here, Madam Speaker, it would appear as though genuinely government wants to provide reasonable retirement for these senior officers, but not at the expense of the many civil servants who are struggling at present times. Because, Madam Speaker, if you are not aware, public servants are barely surviving today because the salaries they are getting are not commensurate with the cost of living at present times. And so government should be more concerned about strengthening or bettering the well-being of these many public servants without whom even this office cannot function. That is why, Madam Speaker, I'm very conflicted that we seem to be prioritizing the interest of these very senior officials, some of whom, in fact, most of whom can actually even survive even without these schemes that we are trying to propose here. Because for argument's sake, if we look at the monthly salaries of some of these officers and the take-home pay after they leave office, I think these are reasonable perks that can enable them to have a decent livelihood after they leave office. So to continue providing for these hefty entitlements, therefore, Madam Speaker, I have a problem. Secondly, Madam Speaker, this proposal seems to be creating a special case for one individual. Presently, the Chief Justice is covered under the laws of Zambia, which is the Judges and Conditions of Service Act of 277, which provides for many other things, his salaries and what he takes home after leaving service. If you go in other jurisdictions, because we do a lot of benchmarking, if we wanted to comply with what is happening in other regions, we could have taken an example of what's happening in South Africa and in Botswana, as highlighted even in the report, that the Chief Justices in those jurisdictions are covered under the existing laws that equally covers the judges. I think that there's nothing so special that we must now create a separate law for the Chief Justice, whereas if we wanted to give them perhaps better or reasonable packages, we could have simply revisited the same Judges and Condition Service Act of 277. Madam Speaker, the other reason why I'm skeptical to support, supporting this proposal are some of these outrageous propositions that are being made in the name of exemptions to when somebody will be entitled to these schemes being proposed here. For me, what I think is that if, or rather a pension is not a favor, it is a reward for somebody's distinguished service to the nation. If we are proposing that the Chief Justice, for the service he has rendered to this country, we must reward them with these hefty, lifelong, benefits, it must not come as if we are doing them a favor. It must come as a token of appreciation for having served the country well. There is no relationship between one getting involved in politics and one being entitled to benefits after having served the nation. So the clause that is providing an exemption as times when the Chief Justice will not be entitled to benefits, being him or rather him or her getting involved in politics, for me, doesn't sit well with me. Just like I argued over the benefits around the former vice president and the president. There's no relationship. It must be stated here that after I serve, if you want to provide a pension for me, I am entitled because I have saved. To stop me from enjoying my entitlements because I've involved in politics is completely unfair. Secondly, there's another exemption when one is convicted after having left office. If a Chief Justice is convicted while he's in office, this is a different case. But when one is convicted after having left office, where is the relation? What is the problem that you want now to deny them of what they are entitled because of their distinguished service to the nation? Madam Speaker, it is because of these clauses that is why I am conflicted in supporting this, even though I recognize that it is imperative for a country to recognize men and women for their distinguished service to this nation. But in the absence of consideration to the general welfare, the social inequalities existing between those in the upper brackets, in the civil service and those in the lower brackets, I am very, conflicted in how I should support hefty, allowances or entitlements for the seniors when we are leaving the juniors unattended to. Madam Speaker, I submit.
The Honourable Member for Chilubi.
Thank you, Madam Speaker. I would like to adapt some of the things that the area speakers pointed out to, especially the interaction of certain things as it may be. But I want to concentrate mainly on the interaction of Section 4 and 6. Madam Speaker, the Section 4 gives, 6 takes away. And under what circumstances? Madam Speaker, when you look at Section 4, Section 4.1, and read together with the schedule, first schedule behind there, it does include the spouse. And when it includes the spouse, Madam Speaker, I know that the bill has talked about Interstate Act, but it has not addressed the Wills Administration and Administration of Estate Act number 60. It only addresses the Interstate Act number 59. And looking at creating a balance, this particular bill is pointing to what the former Chief Justice will lose, even when they are not active in politics. And among the things that they will simply lose is a motor vehicle. In Section 4, subsection 1C, one driver and one motor vehicle. When they come back from active politics, that's what they are likely to lose. The other things will be retained. That's what the bill is saying. Madam Speaker, I know that the spouse of the former Chief Justice receives these benefits as a result of association to the former Chief Justice. And our laws are quite clear in terms of how they cover family members, as I've already referred to the Interstate Act, Cap 159, and the Wills and the Administration of Estate, which is 60. Now, looking at this, you have seen that it has partitioned things that the Chief Justice is going to lose when they get involved in politics. And the subsection, section 4, subsection 1E, indicates that among them is in Schedule 1, which among these things read, diplomatic passport for the former president, for the former Chief Justice and the spouse, medical insurance for the former Chief Justice and the spouse. Of course, these are things from 3 to 5, the spouse is silent. This, Madam Speaker, means that when this former Chief Justice is involved in active politics, it also invites that the spouse loses the diplomatic passport. We have to ask, is it fair? Then it also means that this spouse loses medical insurance because it is attached to the former Chief Justice. And then the issue of getting involved in politics. Madam Speaker, can I really concentrate? This man is really a thorn in my flesh. Yes.
Can we stop being thorns in the honorable member's flesh?
Yeah.
Honorable
It's actually
member,
becoming a thorn in my brain because I have to process these things. Yeah. Madam Speaker, what I'm talking about is that this spouse, who is innocently married to the former Chief Justice, their wife and husband, the former Chief Justice is there, he has not died, they have not divorced, and by contagious arrangement, this spouse benefits from
The honorable member, I didn't even hear what did you say?
I said contagious, Madam Speaker. Yes.
For what?
I said contagious, Madam Speaker. Yes. Madam Speaker, maybe if you can tell that man from making noise, maybe there's a thought wave that I'm trying to promote here. Anyway, you may not know. So, Madam Speaker, what we are trying to say here is that if this Chief Justice dies, and the Chief Justice, by nature of the qualifications, would be a lawyer, and they would have read this particular, by that time it would be an act. They would have also read the Interstate Act, which is 59. They would have also read the Wills Act, which is 60. If this speaker, if this Chief Justice finishes the 5 years, as the law states, and because they have not finished and violated the Constitution, they put under the Wills and the Administration of Estate, which is the Cap 60, they put the wife and the like the way they are supposed to benefit. Then this particular bill says they should vacate from that because it has only tackled the Interstate Act. It means that it leaves the spouse vulnerable, and because it has not taken on board the Wills Act. That's my point. And Madam Speaker, another factor that I want to really appreciate is what the area debaters reaffirmed, that this particular former Chief Justice, when they retire, their former Chief Justice, they can choose a different life. And among the lives that they can choose is to politically interact. Because freedom of assembly in Article 21 and that of association allows them to do so. And it's in the bill, in the Bill of Rights, Part 3 of the Constitution. You can't understand what I'm saying. Yeah, you can't. Really, you can't. From one, you can't understand. So what I'm trying to say, Madam Speaker.
There is a point of order, although we are. What's the point of order, Honorable Member for Mwandi?
Yeah.
Madam Speaker, I stand on a very serious point of order on the member who is currently on the floor of the House. Madam Speaker, the topic at hand is a very, very important motion. The honorable member has been debating for the past 7 minutes, almost. And we've heard nothing. And he has continued on the same trajectory of moving from one end, swinging to another end. If us who are in this house are hearing nothing, I'm wondering what the people that are outside are hearing. Is the honorable member a researcher a law student, in order, Madam Speaker, to stand to stand on the floor of the House, say nothing for 7 minutes, while we've got a lot of work to be done. Madam Speaker, is it in order to continue? Because we are hearing nothing. Madam Speaker, this is standing order number 71. Madam Speaker, I seek your serious ruling. I submit.
Okay. Maybe if the honorable members will pay attention, more attention, they will hear something. That's how the honorable member debates. So let's give him chance so that he expresses himself. May the honorable member continue.
Thank you, Madam Speaker. I can see that you are really just following as a lawyer when I was quoting those, and I can see you are producing different documents. That's why I paid attention, and I was looking this side, not this side. Yeah, so Madam Speaker, what I was trying to say...
Honorable member, I was just constrained to... You are mixing the Interstate Succession Act and the wills. And
yes.
So that's where your debate is not very clear on what you are implying.
No, Madam Speaker, what I was just trying to say, maybe if I can clarify on that one, is that this particular bill has captured what is supposed to be in the interstate. It has a presumptive position that the former Chief Justice can only die, maybe possibly linked to the interstate.
Okay, maybe let's understand. You are talking about Clause 5.
Yes, Madam Speaker.
Clause 5 is talking about where the spouse, where this, for Touchwood, the Chief Justice, the former Chief Justice dies.
Yes.
And he leaves a spouse.
Yes.
Now, when that spouse remarries,
yes,
then she's going to lose this benefit. Yes. That's what it says. So I don't know how COVID came in.
Where it came in, Madam Speaker, is the issue at first started with the schedule, the passport, and the insurance. If you followed me, I said when this former Chief Justice joins politics, it means that by nature of joining politics, he has affected the spouse by losing the diplomatic passport, also losing the insurance for health. That's where I started from. And I did not touch the part that you have touched, especially remarrying. I haven't mentioned the remarrying, Madam Speaker.
So is what you are saying that when the former Chief Justice dies, the spouse should continue retaining the passport, retaining the medical insurance, but then on the foreign trip, it's not saying that the former Chief Justice will travel with the spouse. On local trip will travel. It doesn't state that the spouse will accompany the former Chief Justice. Is that what you are saying?
Yeah, I understand that those in the schedule 3 to 4, they fall off naturally. But what I was saying is the insurance and the diplomatic passport. I was thinking that it would be ideal to maintain them even when the former Chief Justice has passed on.
Then just make a suggestion, propose an amendment.
Yes, that's what I'm trying to say, Madam Speaker, that those should be maintained, since my time has run out. Yes.
Honorable members, let's allow the people who have shown interest to debate. They are helping us in the process. So there's no further debate. The Honorable Minister of Justice winding up debate.
Thank you, Madam Speaker. I would like to thank Honorable Fube, Honorable Mpundu, and the Honorable Member of Parliament for Shwangandu for the debate. And I've taken note of the issues they have raised. If there will be need to make an amendment, we shall do so. Thank you, Madam Speaker.
I put the question. The question is that the bill be now read a second time. As many as are of that opinion say aye. Of the contrary say no. The ayes have it. The ayes have it. The question is resolved in the affirmative. Let the bill be read a second time.
The benefits of former Chief Justice Bill, National Assembly Bill number 67 of 2026.
Committee stage to be taken when?
Tomorrow, Madam Speaker.
Committee stage to be taken tomorrow, Tuesday, 12th May 2026. Next order.
The Public Service Pensions Bill, National Assembly Bill number 69 of 2026, second reading.
The Honorable Minister of Finance and National Planning.
Madam Speaker, I beg to move that the bill be now read a second time.
Thank you. The question is that the bill be now read a second time. Any debate? The Honorable Minister of Finance and National Planning.
Madam, I have the honor of presenting the Public Service Pension Bill, National Assembly Bill number 69 of 2026. The objects of the bill are to, 1, continue the existence of the Public Service Pension Fund Board, rename it as the Public Service Pension Fund, and redefine its functions. 2, reconstitute the board of the named Public Service Pension Fund and redefine its functions. 3, continue the existence of the membership, contribution, and the benefit structure, and name it as the Public Service Pension Scheme. 4, establish the Occupational Pension Scheme. 5, continue the existence of the Public Service Pension Fund in relation to its property component and rename it as the Pension Fund. 6, establish the Occupational Pension Fund. 7, provide for the collection of pension contributions. 8, provide for the payment of benefits. 9, provide for the actuarial valuation of the Public Service Pensions Scheme and Occupational Pension Scheme. 10, repeal and replace the Public Service Pensions Act, Chapter 260 of the laws of Zambia. And 11, provide for the matters connected with or incidental to the foregoing.
Sorry. Any further debate? The chairperson of the Committee on Parastatals, the Honorable Member for Mansa Central.
Madam Speaker, the committee is in support of the bill. This notwithstanding, it wishes to make the following observations and recommendations. Madam Speaker, the committee observes that Clause 26(2)A of the bill lacks clarity regarding the treatment of members who exit the scheme between the ages of 56 and 59. This may result in inconsistent interpretation and application of the provision. The committee therefore recommends that the clause should be amended to expressly provide for the applicable treatment of members exiting the scheme within that age range. Madam, the committee also observes that the proposed dual pension system may result in fragmentation, iniquities, and increased administrative complexity. This is particularly so in view of differing rules across parallel schemes and the uncertainty surrounding the future of the defined benefit arrangement. The committee therefore recommends that the bill be amended to provide clear long-term policy direction on pension reform, explicitly stating whether the occupational pension scheme will replace the public service pension scheme or operate alongside it on a permanent basis. Madam Speaker, with respect to the benefit design and eligibility thresholds, the committee observes that clauses 28 to 52 of the bill introduce minimum contribution thresholds aimed at ensuring sustainability and efficiency in the pension scheme. However, it is concerned that these thresholds may inadvertently exclude some members from accessing periodic pensions, therefore weakening long-term retirement security. The committee further notes the risk that reliance on lump sum payments alone may result in premature depletion of retirement benefits. The committee therefore recommends that the bill should be amended to introduce a more balanced benefit structure, including proportional or blended pension options, and that qualifying thresholds be reviewed to enhance equity, broaden coverage, and strengthen income security in retirement. Madam Speaker, with regard to benefits on discharge or dismissal, the committee observes that Clause 32 does not clearly provide for the treatment of employer contributions in such circumstances. It notes that the absence of clarity whether these contributions are to be forfeited, deferred, or refunded may create uncertainty in the administration of the scheme. In this regard, the committee recommends that the clause should be amended to clearly stipulate the treatment of employer contributions upon a member's discharge or dismissal. Madam Speaker, in conclusion, I wish to thank you and all the stakeholders for the support rendered to the committee throughout these deliberations. Madam Speaker, I thank you.
Thank you very much. Any further debate? The Honourable Member for Kamfinso.
Madam Speaker, thank you very much once again for allowing me to make a very few comments, Madam Speaker, on this very, very important bill that is before this August House. The bill, Madam Speaker, is the Public Service Pensions Bill. Madam Speaker, I have had time to go through the report that has been presented by the chairperson of the committee, and I note that one of the things that the committee did highlight is the issue of having a dual pension scheme framework. And this is the basis, Madam Speaker, for my debate this evening, the issue to do with a dual pension scheme framework. For those that may not have had time to go through this draft bill, Madam Speaker, the bill under Part 3 is basically creating a new scheme. So currently, we only have just one scheme under the Public Service Pensions Fund. But what this law is proposing, Madam Speaker, and this is something that I totally support, is basically the splitting of the scheme into two things. And that basically will answer the concern from the committee. The scheme is being split into two. Number one, we are going to have what is being called the Public Service Pension Scheme. This is what will allow those that are currently contributing to the scheme to remain on the Public Service Pension Scheme, meaning those that are already enrolled will remain on this particular scheme. The old security wings officers will remain on this scheme, and obviously those who will be employed, officers who are defense officers, Madam Speaker, will remain on the old scheme. But there's a new scheme that is being proposed under Part 4 of the bill, and this is what they are calling the Occupational Pension Scheme. This is where the new members will now have to join, not those that are in the defense wings, but those that obviously are being employed in public service. A new scheme is being proposed. Madam Speaker, the difference basically here is about the benefits that people would want to accrue. Because if you are going to be an employee and you are under a specific scheme, the old benefits should also apply to you as a new public service worker. And that is why, Madam Speaker, Part 3 of the bill and Part 4 of the bill is introducing two separate schemes. And this is why, Madam Speaker, as I support this innovation, and this is something that I alluded to even yesterday, Madam Speaker, it will be important that one employee, Madam Speaker, enjoys the benefits of the two schemes, the Social Security scheme and the occupational scheme. In this occupational scheme, Madam Speaker, the new members are going to enjoy two very, very important benefits under this product, the home ownership product. I'm aware that those who are current contributors, Madam Speaker, of the public service pension scheme do enjoy the benefits of home ownership. This benefit is going to be extended to the new entrants on the occupational scheme. So there will be no discrimination of any sort. At the same time, Madam Speaker, the fact that the new entrants will now have the option of even belonging to NAPSA, it simply means that they will be contributing on one hand to NAPSA, and on the other hand, they will be contributing to the occupational scheme under the public service pension scheme. And the total contribution may look very high, 16.5 as a total contribution, but this is not coming from the employee only. It's also coming from the employer, meaning 8.25% from the employee and 8.25% from the employer. This is provided for, Madam Speaker, under Clause 13 and under Clause 14 of the bill that is before us today. So, Madam Speaker, what am I trying to emphasize? The reason these reforms are coming, Madam Speaker, is to ensure that we have fairness across the public sector. You work for a public sector unit, Madam Speaker, you don't want to be looking to your colleagues who are getting a different amount of money in terms of their benefits. You want to enjoy the benefits that come with belonging to a pension scheme. In short, Madam Speaker, the people of Kamfinsa, where I know we have workers, Madam Speaker, the workers from my constituency have been asking what will be the benefits of us with these reforms. My message to the people of Kamfinsa is that you now have the option of belonging to two schemes, NAPSA and the new occupational scheme. You have the option of enjoying the benefits of home ownership. And let me also indicate, Madam Speaker, we have an institution, a microfinance under the public service pension scheme. People will now be able to draw benefits from that microfinance. So, Madam Speaker, in short, the people of Kamfinsa, with those particular comments, do support the proposed reforms because they are very critical to the welfare of our workers. I thank you, Madam Speaker.
Thank you. The Honourable Member for Kanchibia.
Madam Speaker, I want to thank you once again. Allow me to also thank the committee, the chairperson, and the seconder for moving this very important and progressive report and this bill. I want to also thank the government, the executive, that this bill, Madam Speaker, represents one of the most important social security reforms in public service over the years for our workers. What this bill has done, Madam Speaker, is to respond to the existing gaps, the inequalities, and the sustainability concerns which have disadvantaged civil servants for the longest of time. And so this bill comes to modernize the pension scheme. It strengthens governance. It also expands social protection for the workers in the public service. The framework provided under this bill, Madam Speaker, aligns with international best practice on pension sustainability, portability, governance, as well as retirement security. Madam Speaker, with your indulgence, I'll restrict myself to a few areas, and I know that my good brother, Honorable Kangombe, has alluded to some of the points that I could have touched on. Portability benefits, and I make reference to Clause 43 onwards. Madam Speaker, what this is doing in terms of benefits to the civil servants is that members can transfer pension contributions between schemes. In essence, this protects contributors who move between and across the sectors. This is very important, Madam Speaker, because workers don't have to lose accumulated retirement value because of employment transitions. Madam Speaker, labor mobility should never punish workers by eroding their pension security. Madam Speaker, of importance is what the report makes reference to as an observation under 3. The appeal for flexible lump sum access. That while periodic pensions promote long-term security, contributors should also enjoy meaningful lump sum access upon retirement. Many retirees, Madam Speaker, need immediate capital in terms of housing, medical expenses, education for dependents, farming and entrepreneurship, debt clearance, etc. And so this House, Madam Speaker, has consistently recognized the need for dignified retirement through access to lump sum benefits. Contributors then must not retire into liquidity poverty after serving the nation faithfully for so many years. Madam Speaker, the committee makes recommendations which the people of Kanchivia do support. The first one is the treatment of employer contributions after dismissal. And we make reference to clause 32 under the committee observation under 4. Madam Speaker, the bill needs to clearly state what happens to employer contributions when an employee is dismissed or discharged. This is important because ambiguity may create disputes and uncertainty, and contributors deserve legal certainty requiring or regarding accrued pension rights. Madam Speaker, of commendable or worth commending is the governance and accountability embedded in this bill, and also what this bill brings in terms of economic and national importance, economic benefits for our people. Because we know that a strong pension system reduces old age poverty, promotes financial inclusion, increases long-term savings, strengthens domestic capital markets, enhances social security, and pension reform is therefore both a social and economic reform. So, Madam Speaker, as we support this very important report, allow us to re-echo and make a clarion call that it is important to have refinements where necessary, including the retirement age clarity, treatment of employer contributions, long-term policy direction, balanced sum access. With these improvements, Madam Speaker, this bill can become one of the most progressive and transformative instruments for retirement, allowing our people to retire with dignity and ensuring social security in Zambia. Madam Speaker, as I close, a nation that honors its workers in retirement strengthens confidence in public service and builds a more just and compassionate society. Madam Speaker, with those few remarks, the people of Kanchivia support the report.
Thank you. The Honorable Minister of Finance and National Planning, winding up debate.
Thank you, Madam Speaker. Madam Speaker, first of all, I want to thank your committee for the points they've raised. Let me briefly address some of them. The age of retirement. Some stakeholders were concerned that clauses 26.2 was unclear and required clarification on the treatment of members who exit the scheme between the ages 56 and 59. The provision of the Public Service Pension Bill relating to the retirement age is aligned with the conditions of service applicable in the public service, as members of the scheme are drawn from the public service. Under the current framework, retirement from the public service is specifically provided for at the ages 55, 60, and 65, being early, normal, and late retirements, respectively. However, members may exit the public service between the ages 56 and 59, and the available modes for exit include resignation, retirement on medical grounds, and so many. Consequently, the bill adequately provides for the treatment of members exiting the scheme in accordance with the condition of services. On the dual pension scheme framework, some stakeholders were concerned that the provision for dual pension system might fragment the public service pension framework by creating two parallel schemes with different rules, benefits, and risk structures. They were of the view that uncertainty regarding the long-term direction of reform, particularly whether the defined benefit scheme would be phased out or continue alongside the defined contribution, made fiscal and actuarial planning more difficult. Madam Speaker, the proposed arrangement is a deliberate measure intended to ensure sustainability, protect accrued rights, and facilitate smooth introduction of the new pension scheme. The existing defined benefit scheme will continue to cater for the members already enrolled under that arrangement, and the new entrants from the Defense Force and National Security Services, thereby safeguarding the benefits already accrued. On the other hand, the defined contribution scheme is intended for new entrants in the public service scheme. Madam Speaker, the issue of benefit and design. Some stakeholders were concerned that while the bill introduced a structured and predictable benefit framework linked to contributions and defined contingencies, it placed strong emphasis on a minimum contribution. Members who did not meet these thresholds would receive only lump sum benefits, raising concerns about long-term income security. They noted that although lump sums offered short-term flexibility, they might quickly be depleted, leaving the retirees vulnerable. Madam Speaker, the bill seeks to establish a structured and sustainable pension framework that balances adequacy of benefits, financial sustainability of the scheme, and fairness among members. Madam Speaker, these are some of the concerns that were raised, which I have tried to address. And with that, I thank the House for the support.
Thank you. I put the question. The question is that the bill be now read a second time. As many as are of that opinion say aye. Aye. Of the contrary say no. The ayes have it. The question is resolved in the affirmative. Let the bill be read a second time.
The Public Service Pensions Bill, National Assembly Bill number 69 of 2026.
Committee stage to be taken when?
Tomorrow, Madam Speaker.
Thank you. Committee stage to be taken tomorrow, Tuesday, 12th May 2026. Next order.
The Local Authorities Superannuation Bill, National Assembly Bill number 70 of 2026, second reading.
The Honorable Acting Minister of Local Government and Rural Development.
Madam Speaker, I beg to move that the bill be now read a second time.
Thank you. The question is that the bill be now read a second time. Any debate? The Honorable Acting Minister of Local Government and Rural Development.
Madam Speaker, I wish to thank you for according me this opportunity to render a statement to this House on the Local Authorities Superannuation Bill number 70 of 2026. Madam Speaker, the Local Authorities Superannuation Fund is a statutory institution under the portfolio of the Ministry of Local Government and Rural Development. It is responsible for the administration and management of pension benefits for employees of local authorities and associated institutions across Zambia. The existing legal framework governing LASIF is the Local Authorities Superannuation Fund Act, CAP 284, enacted in 1962. That legislation is over 60 years old. It was conceived in an era of fundamentally different governance standards, economic conditions, and pension philosophy. It has long outlived its utility. The government has undertaken a comprehensive review and determined that the time for legislative modernization is overdue. The Local Authorities Superannuation Bill 2026 is the product of that determination. What's the rationale for the bill, Madam Speaker? The case for the legislative reform addresses three broad challenges, being legal inadequacy, institutional constraints, and outdated pension framework. Madam Speaker, on legal inadequacy, the current Act contains critical legal gaps that have materially hampered LASIF's ability to function as an effective pension institution. Chief among these is the absence of legal mechanisms for the fund to coexist with other statutory pension schemes, particularly the National Pension Scheme Authority, NAPSA. This legal deficiency compelled LASIF to halt the admission of new members in February 2000, a situation that has persisted for over 2 decades, leaving a generation of public employees without adequate occupational pension coverage. 2, institutional and governance constraints. LASIF has been operating under significant application constraints that limit its capacity to protect members, enforce compliance by employers, and adapt its operations to changing economic conditions. The governance architecture established under CAP 284 is outdated and does not reflect the principles of modern corporate governance expected of public institutions. 3, outdated pension framework. Government's commitment to public sector reform demands that the pension governance for local authority employees meet the same standards applicable to other public institutions. Members of LASIF deserve the same protections, the same transparency and sustainability assurances that modern pension legislation provides. The bill is the government's decisive response to that obligation. What are the key features of the bill, Madam Speaker? The bill is comprehensive and forward-looking. Its features are as follows. 1, 2-scheme architecture. One of the most significant structural reforms in the bill is the introduction of a dual-scheme framework to serve different categories of employees. The superannuation scheme continues the existing defined benefit membership, contributions, and benefit structure for long-serving members who were part of the former fund. This scheme preserves accrued rights and provides certainty of benefit for those who have contributed over many years. The Occupational Superannuation Scheme is a newly established defined contribution scheme designed to accommodate employees who joined local authorities and associated institutions after February 2000 and who have been excluded from LASIF membership. This scheme, Madam Speaker, will be funded by the Occupational Superannuation Fund, which is separately established under the bill. Each scheme, Madam Speaker, has its own fund, its own contribution framework, and its own benefit structure. but both are administered and managed under the same institution umbrella, the Local Authorities Superannuation Fund. This architecture resolves the legal barrier to coexistence with NAPSA and creates a sustainable pathway for extending pension coverage to a new generation of local authority employees. Madam Speaker, on contributions framework, the bill establishes a clear and enforceable contributions framework. Registered employers are required to pay mandatory contributions comprising both the employer's share and the member's share by the 10th day of each month following the month to which contributions relate. 3, benefit structure. The bill provides a comprehensive and clearly structured benefits framework for both schemes. Under the superannuation scheme, members are entitled to retirement benefits, that's a lump sum, and pension, ill health retirement benefits, reorganization benefits, resignation and discharge benefits, and death benefits. Under the occupational superannuation scheme, benefits are determined by reference to each member's fund credit, the aggregate of contributions, and applicable investment returns, ensuring transparency and individual accountability. 4, benefits protections and portability. The bill explicitly protects member benefits from attachment, sequestration, or levy for debts except in respect of court orders for maintenance of a spouse, former spouse, child, or dependent. The bill also provides for the portability of benefits, enabling members who separate from a registered employer to transfer their contributions or accrued benefits to another scheme. This provision, Madam Speaker, ensures that career mobility does not come at the cost of pension continuity. Madam Speaker, the Local Authorities Superannuation Bill number 70 of 2026 represents a landmark reform in the governance of pension benefits for local authority employees in Zambia. It replaces legislation that is over 60 years old with a modern, comprehensive, and sustainable framework that serves the interests of members, the interests of employers, and the public. I therefore appeal to this august House to give the bill its full support and recommend that the Local Authorities Superannuation Bill number 70 of 2026 be read a second time and enacted into law. Madam Speaker, I thank you.
Thank you. Any further debate? The chairperson of the Committee on Parastatal Bodies, the Honorable Member for Mansa Central.
Madam Speaker, the committee is in support of the bill. This notwithstanding, it makes the following observations and recommendations. Madam Speaker, the committee observes that although the bill provides a comprehensive pensions reform framework, there are a number of governance, structural, and implementation issues that require strengthening to ensure accountability, fairness, and sustainability. In particular, the committee observes that the minister's significant role in appointing board members and the chairperson may create a risk of perceived or actual political interference. In this regard, the committee recommends that appointments should be merit-based and competence-driven, supported by safeguards to limit ministerial discretion. Madam Speaker, the committee further observes that the contribution framework, while actuarially sound, may be undermined by non-compliance, particularly from fiscally constrained local authorities. In this regard, the committee recommends strengthening enforcement through structured arrears management, proportionate penalties, robust monitoring, and limited flexibility for genuine fiscal distress. In addition, the committee observes inconsistencies in the provisions governing benefits upon exit from the scheme. In this regard, the committee recommends that the bill should be amended to clearly define benefits payable to members exiting between the ages of 56 and 59, and to ensure consistency between relevant clauses. Madam, with regard to portability of benefits, the committee observes a lack of clarity regarding how transferred benefits are treated in meeting qualifying requirements. In this regard, the committee recommends that the bill should explicitly provide that transferred fund credits reflect the corresponding contribution periods for purposes of determining eligibility. Madam Speaker, the committee also observes that Clause 51 on sub-schemes lacks clarity and may lead to duplication of pension products and regulatory uncertainty. In this regard, the committee recommends that the definition of sub-scheme be strengthened and that consultation with the Pensions and Insurance Authority be made mandatory prior to establishment of sub-schemes. Madam Speaker, in conclusion, I wish to thank you and all the stakeholders for the support rendered to the committee throughout its deliberations. Madam Speaker, I thank you.
Thank you very much. Any further debate? The Honourable Member for Kamfinsa.
Madam Speaker, once again, I'm grateful that you've allowed me to make a few comments on this very, very important piece of legislation. For those that may be wondering who are the members of LASIF, Madam Speaker, LASIF is where all local authorities prior to 2000 workers were actually contributing. If you are employed in any council in Zambia prior to the year 2000, your contributions were obviously going to LASIF. And Madam Speaker, after the year 2000, of course, there were reforms. Workers were told, if you are employed in a council, go and contribute to NAPSA. So it is council workers, Madam Speaker, workers for the National Housing Authority, and workers, some of them from ZESCO. This is LASIF. Unfortunately, Madam Speaker, because of the 2000 reforms, LASIF lost the membership. And if you don't have the members, Madam Speaker, if no new members are being added to your scheme, the scheme will have challenges of liquidity. So one of the things that these reforms is going to resolve, Madam Speaker, is to reopen LASIF, to allow people now to begin paying money towards LASIF so that the benefits that ideally should come with this pension scheme would then be able to be extended to the workers. Technically speaking, Minister of Local Government, what you are proposing, and I fully support, is that we need to split LASIF into two things. Number one, all those that were on LASIF prior to 2000, Madam Speaker, will remain on the superannuation fund, which is the old scheme. And then everyone else, Madam Speaker, who is going to be employed in any local authority in Zambia after this law is passed, because I'm quite certain that everyone will support this amendment. Once this law passes, Madam Speaker, everyone who is going to be employed in any council in Zambia will have to be a member of LASIF. And one of the things that people have been asking, especially people that have been working in councils, there are about 35,000 workers who are currently with NAPSA, who are working for councils. But because NAPSA, Madam Speaker, is a social security scheme, there are benefits that they are not getting. And that is why these reforms become critical. The three benefits, Madam Speaker, that the workers are going to begin to benefit, especially those that are going to be employed, plus the 35,000 that are currently on NAPSA, Madam Speaker, three very, very important benefits. Number one, at retirement, currently, Madam Speaker, LASIF provides for two options. Either you get 1/3 of your savings or you get 2/3 of your savings. That is what the old LASIF provides. The new reforms are proposing, Madam Speaker, and for the benefit, these councils have got workers where these members of parliament are actually domiciled. Madam Speaker, at retirement, workers who are now going to join LASIF will be able to draw 40% of their savings at retirement as a lump sum amount, Madam Speaker. Secondly, there's going to be an option of acquiring a loan that is backed by your salary. Because, Madam Speaker, if you are working and you want to do other things, Madam Speaker, LASIF should be able to guarantee certain things. And that is why this salary-backed loan, Madam Speaker, becomes very critical for those that have been asking, what are the benefits of belonging to LASIF once the scheme is reopened? Madam Speaker, third and most importantly, the issue of housing. Madam Speaker, one of the challenges that our workers face is that they can't have access to money to build a house. So one of the reforms that I expect government to quickly implement once the law is changed, Madam Speaker, is for the mortgage to be made available for workers that are employed in councils to be able to draw funding to construct a house. These benefits, Madam Speaker, are very important because it is the only thing that will attract our workers to be able to be interested to belong to this very, very important scheme. So, Madam Speaker, the scheme has got two options. Basically, the new workers will be on the occupational scheme, and the old workers, eventually we know that there are few workers that were there prior to 2000. Those eventually will reduce in number. So, Madam Speaker, the people of Kamfinsa are mindful that Zambia has got 116 councils in Zambia, and there are workers that are going to be employed by the Local Government Service Commission. Those members will need to enjoy these benefits. The benefits that they've been crying for and the benefits that will now accrue as they work for local authorities, ZESCO, and the National Housing Authority. Acting Minister of Local Government, I do support the amendments. I do support the reforms. I have worked in an environment where workers are uncertain about their benefits. Having had the privilege of serving as councillor for 10 years and mayor for 5 years, I am excited, Madam Speaker, that these reforms are finally taking place. I thank you, Madam Speaker.
Thank you. The Honourable Member for Chama North.
Thank you, Madam Speaker, for according me this opportunity also to add my voice on this very, very important bill, the Local Authority Superannuation Bill. Madam Speaker, I'm on the record that a question was brought on the floor of this House where I was asking the Minister of Local Government whether government had plans to amend the LASIF Act. And the Minister told the nation on this floor of the House that indeed the government had plans to amend the LASIF Act. And therefore, I am very, very excited, Madam Speaker, having served as General Secretary in the Union at ZESCO, I know how workers, former workers at ZESCO have been suffering. I know how workers in local authorities, National Housing Authority. So this is a very, very progressive bill which needs to be supported. Just like what the Honorable Kangombe has said, LASIF was representing ZESCO workers, workers from the local authorities, and also national housing. And the LASIF pension was more lucrative than National Provident Fund. Until 2000, when NAPSA was established, that LASIF now stopped receiving new members. And a pension scheme can only survive if it receives new members. Those who are retiring are paid off, and those who are coming in are financing those who are retiring. But where you stop new members, how do you expect that pension scheme to be sustainable? So this bill, Madam Speaker, is very, very progressive. I know that LASIF has been depending on government grants. Every time as union leaders, we used always to go to the Ministry of Finance, the Ministry of Labor, trying to push for grants. And this has been very, very difficult, Madam Speaker. And at least now, the future workers, I think now with these reforms in LASIF, I feel that it is good for the workers. Madam Speaker, I know that even the issues of annuity, this time you find that the annuity, it does not reflect the prevailing economic situation in the country. where people are getting maybe a 300 kwacha, 400 kwacha, 1,000. I don't think that is enough. And I hope that with these new reforms, our former workers will be able to get something when they retire. So with these few remarks, I fully support this amendment and also these reforms in LASIF. I thank you, Madam Speaker.
Thank you very much. The Honorable Acting Minister of Local Government and Rural Development, wind up debate.
Thank you, Madam Speaker, and let me thank the committee for the work they did. Let me also thank Honorable Kangombe for that submission, as well as the ex-unionist, Honorable Mutayachalo. Madam Speaker, it's very, very important that I respond to some very, very important issues which the committee brought about very, very quickly. And number one is on governance, institutional structure, and board position. I think there was many queries there. Our feedback is that the appointment of board members by the minister is standard practice in public institutions that are under the ministerial oversight. Further, the bill has provided criteria that will be used to appoint board members, which includes expected competences. The tenure and all governance-related provisions will be provided in the schedules. On dual pension scheme framework, Madam Speaker, we understand that while there will be two parallel schemes under this Act, their existence, Madam Speaker, is temporal. The old scheme, the superannuation scheme, provides existing membership, which will eventually wind up and will pave the way for the new scheme. That will be supplementary to benefits under NAPSA. Therefore, the inequality being talked about is merely transitional, and in the long term is projected that benefits will become comparable among public workers. Madam Speaker, on contribution framework and penalty regime, the comments and recommendations are appreciated. In alignment with the comments and recommendations, the bill has introduced, Madam Speaker, an inspectorate in Part 10 and other provisions that have strengthened the ability of LASIF to collect contributions beyond ordinary means. Number 4, Madam Speaker, on reorganization and the employer pre-funding obligations. These exist under the provision relating to reorganization and are purely triggered by the employer. Therefore, the requirement to impose pre-funding of benefits under this section is meant to align with the Constitution, which requires that requirement benefits be paid on the last day of work. Therefore, Madam Speaker, we recommend maintaining the provision as it will allow employers to plan reorganizations before actioning them. Madam Speaker, on benefits on retirement for members of the superannuation scheme and benefits on reorganization or discharge of members of the scheme, the bill provides for retirement, Madam Speaker, at ages 55, 60, and 65. Therefore, if a member exists between 56, for example, 59 years, such an exit would not be treated as a retirement, but will be subjected to the respective benefits corresponding to the circumstances related to their exit. The bill, Madam Speaker, aligns with conditions of service applicable to public workers covered by LASIF. Madam Speaker, on portability of benefits, the concern on converting transferred accrued benefits to corresponding contribution months will be dealt with through the regulations. And lastly, Madam Speaker, on sub-schemes, the Ministry considers recommendation to consult the Pensions and Insurance Authority prior to the establishment of sub-schemes as a standard administrative process, which should not be prescribed into law. LASIF consults, Madam Speaker, it consults multiple stakeholders prior to making any amendments. And lastly, Madam Speaker, on regulations, this is the last one, regulations, clause 9.4 in reference is under financial provisions, that's in the second schedule, which relates to the finances of LASIF as an institution and not relating to investments of funds related to schemes which is provided for through prescription under Section 48. Indeed, the committee noticed this, and our clarification is that this highlights the clause 48, which highlights the provisions for investments of funds of the schemes will be done through the necessary regulations. Madam Speaker, I thank you.
Thank you very much. Order. I put the question. The question is that the bill be now read a second time. As many as are of that opinion say aye. Of the contrary say no. The ayes have it. The ayes have it. The question is resolved in the affirmative. Let the bill be read a second time.
The Local Authorities Superannuation Bill, National Assembly Bill number 70 of 2026.
Committee stage to be taken when?
Tomorrow, Madam Speaker.
Thank you. Committee stage to be taken tomorrow, 12th May 2026. Next order.
The Public Gathering Bill, National Assembly Bill number 71 of 2026, second reading.
The Honorable Minister of Home Affairs and Internal Security.
Madam Speaker, I beg to move that the bill be read now for the second time.
Thank you. The question is that the bill be now read a second time. Any debate? The Honorable Minister of Home Affairs and Internal Security.
Thank you, Madam Speaker. I'm grateful for the opportunity to present this statement on the Public Gatherings Bill number 71 of 2026. At the outset, allow me to express my sincere appreciation to the Committee on Legal Affairs, Human Rights and Governance for its diligent and thorough consideration of this bill. I also commend all stakeholders for their constructive input, which has greatly enriched the legislative process and contributed meaningfully to the development of the bill. Madam Speaker, the proposed bill seeks to provide a modern legal framework for the regulation of public assemblies, meetings, processions, and demonstrations in Zambia. It repeals and replaces the Public Order Act of 1955, aligning the governance of public gatherings with current constitutional principles on human rights, public order, and democratic participation. The process of drafting this bill involved extensive collaboration and consultation with a wide range of stakeholders to ensure the legislation aligns with the needs and expectations of the Zambian people. We engaged the civil society organizations, including religious bodies, political groups, NGOs, as well as traditional leadership throughout the developmental process. The development of this bill was necessitated by the incessant public outcry and court proceedings over the provisions and implementations of the Public Order Act, whose provisions were contentious. Madam Speaker, the central objective of the bill is to strike an appropriate balance between safeguarding fundamental freedoms, particularly the rights to assembly, association, expression, and movement, and ensuring the maintenance of public order and safety during public gatherings. The bill introduces several notable reforms, including a shift from a permit-based system to a notification-based approach, supported by defined timelines for response. 2, provision for deemed approval where authorities do not respond within stipulated periods. 3, clearly define grounds and procedures for limiting or restricting gatherings, including the requirement to provide written reasons and opportunities for compliance. 4, explicit duties imposed on authorized officers to act fairly, impartially, and in accordance with the constitutional standards. 5, formal recognition of the role of the media in observing and reporting on public gatherings. And 6, enhanced transparency through public access to a register of notices. Madam Speaker, when enacted, the law will improve legal clarity and minimize disputes between organizers and law enforcement, deepen democratic participation by safeguarding the right to peaceful assembly, and enhance accountability among law enforcement officers through clearly defined obligations and review mechanisms. Madam Speaker, in conclusion, the Public Gatherings Bill 2026 marks a progressive transition from a predominantly control-oriented legal framework to one that is right-based, transparent, and procedurally fair. By repeating the outdated Public Order Act and introducing modern safeguards, the bill seeks to promote lawful, peaceful, and orderly public participation while preserving public order and security. I urge all honorable members to support this bill. Madam Speaker, I thank you. I submit.
Thank you very much. Any further debate? The chairperson of the Committee on Legal Affairs, Human Rights and Governance, the honorable member for Kalabo Central.
Madam Speaker, in accordance with its mandate, the committee considered the Public Gathering Bill, National Assembly Bill, number 71 of 2026, which seeks to provide a modern legal framework for the regulation of public gatherings, while promoting the protection of the rights to freedom of assembly and ensuring public order and safety. Madam Speaker, this is an important bill as it seeks to replace the Public Order Act, which has long been criticized as outdated and inconsistent with the constitutional principles. The bill presents an opportunity to transition from a restrictive approach to a more right-based framework that facilitates rather than controls the exercise of fundamental freedoms. The committee notes a number of positive features in the bill. In particular, the bill introduces clearer procedure for the notification and management of public gatherings, recognizes the duty of authorized officers to promote and protect constitutional rights and freedoms, provides for media access to public gatherings, and repeals an outdated legal framework that has given rise to considerable legal and practical challenges. The committee further notes that stakeholders were generally in support of the bill and agreed that there is need for a more modern, predictable, and constitutionally compliant framework for the management of public gatherings. Madam Speaker, the committee is satisfied that the bill strikes an appropriate balance between the protection of the right to freedom of assembly and the need to preserve public order and safety. While some stakeholders were of the view that the requirement for notice and approval to hold a public gathering was an affront to fundamental right to assemble. The committee notes that this requirement provided under the bill is intended to facilitate the orderly coordination and management of public gatherings. The committee is also satisfied that the powers granted to authorized officers under Clause 9 are necessary to enable timely interventions in situations that may threaten public order, safety, or property. Further, Madam Speaker, the committee notes that the exemptions provided under Clause 3 are necessary to enable certain office holders and persons to effectively perform their official and civic duties. The committee also notes that these exemptions do not apply during an election period or after the dissolution of Parliament, which serves an important safeguard. The committee is further satisfied that Clause 13, which creates offenses relating to non-compliance with the requirement of the Act, is necessary to promote compliance with the law and ensure the orderly conduct of public gathering. Madam Speaker, the committee also supports the immunity provided to authorized officers under Clause 16 for acts done in good faith, as this is necessary to enable them to discharge their functions effectively and without fear of personal liability arising from actions undertaken in the course of duty. However, Madam Speaker, the committee observes that the appeal mechanism under Clause 15 may present practical challenges in accessing the appeals process in a timely and effective manner. The committee, therefore, recommends that consideration be given to an appeals framework that enhances accessibility and ensures the expeditious determination of appeals. In conclusion, Madam Speaker, the committee supports the bill and is of the view that it represents an important step towards establishing a more modern, right-based, and predictable legal framework for the management of public gatherings in Zambia. I, therefore, urge the honorable members to support the bill. Madam Speaker, I thank you.
Thank you very much. Any further debate? The Honorable Member for Nkana.
Madam Speaker, this is a very sad day for Zambia. This is a sad day for our democracy. For me, this feels like performing the last rituals to bury our democracy. The levels of insincerity around the objectives of this proposed bill is very concerning. I never thought the Honorable Minister would make such a proposal. Madam Speaker, for a very long time, the issue of the Public Order Act has been very contentious. Governments have come in, the opposition would cry foul. Government changes, the ruling party starts to enjoy. Today, the UPND government sees an opportunity to inflict more pain into our democracy. To understand this, Madam Speaker, it will take you to perhaps look at some of the definitions. Madam Speaker, it will interest you. public gatherings means a meeting, according to this bill, a meeting or assembly or procession of 3 or more people. 3. Madam Speaker. Madam Speaker, the Public Order Act that is being repealed with this bill had only one problem: the enforcement of that act. The enforcement was wrongly being done, which gave rise to so many misunderstandings. Honorable Minister, you understand that the Christine Mulundika case had settled the issue around the Public Order Act, save for the enforcement that was wrongly being done, because that case of 1995 demanded that anyone who wants to have a public gathering simply needed to notify the police. That abuse of the notification is what gave rise to most of the problems that we've been facing around the Public Order Act. This attempt, I thought, was meant to cure that problem. But this is where I have a problem, Madam Speaker. When you read this bill, Madam Speaker, in Part 3, this act shall apply to a public gathering held in the public. 2, despite subsection 1, this act does not apply to public gathering held by the President, by the Vice President, by the Speaker, Deputy and Second Deputy Speaker, by Minister, by MP, and by Mayor and Councillor. There are exceptions that in the course of our conducting business, we are not expected to get a permit. But let's see what they now do in Part 3. The exemption for persons under Section 2, those of us who were exempted not to be getting permit, are now, this is what now 3 is saying, the exemption for a person under Section 2, C, D, E, and F, shall not apply during an election campaign and during an election. What the minister is saying, that during a campaign, if you want to have any gathering, you will have to get a permit. That is what this bill is saying. Imagine having to get a permit during campaign. And what are they demanding? That you must notify the police 5 days prior to holding that gathering. Interestingly, this is not just affecting, Madam Speaker, from the definition in this bill, this is not just affecting political gathering. This is affecting any form of meeting. And, Madam Speaker, this bill is suggesting any form of meeting, and public place is being described to mean a road, to mean a highway, to mean any public place where you can access through paying or otherwise. And you know what that means. It means even lodges and everything else. Those include public places. And this bill is now dictating to meet 3 or more people, you'll be expected to notify the police 5 days prior to that. Madam Speaker, I never thought that anybody would be outrageous in proposing that 3 people meeting would need to get a permit. Madam Speaker, Madam Speaker, the Public Order Act had entitled police officers or law enforcement officers to be using discretion away from what the law provided. This bill further goes on to again entitle police officers to be using discretion, suggesting that when they suspect that there's going to be, some confusion at a public gathering, then they will not give you a permit. What was sought to be cured under the Public Order Act has now been made even worse, Madam Speaker. The stakeholders have submitted How can you now include spontaneous activities? Spontaneous activities would include campaigns. Madam Speaker, honestly speaking, in today's time, when people are supposed to enjoy, because the tenets of democracy is people's enjoyment of their rights and freedom to assemble and associate. How can people assemble if you are going to be expecting them to always be notifying the police every other time they want to assemble? Interestingly, here we are not even restricting that assembly to a large group. We are reducing that assembly to 3 people. Madam Speaker, here, this is not about politicians. When you insist 3 people meeting must get a permit, Madam Speaker, the law has got no eyes. It doesn't look at faces to see that these are politicians, they are the ones to get a permit. Anyone who meet, even for social gathering, this is one of the observations that has been made by the people that appeared before your committee, that this will now include or will now, subject even people that are going to meet for social gathering. For as long as there will be 3 and more, they will now be controlled under this act. Imagine, if Honorable Mposha had 3 wives and met on the road. This bill would require him to get a permit. This is how outrageous these propositions are. A meeting over a social beer or a social chat in public places would require now that you get a permit. Honorable Minister, can we be sincere for once in your life? You cannot in this time propose these outrageous propositions. You can't. This is unfair to the people of Zambia. This is not what the people of Zambia voted for you. You are being insincere. You are being careless in this.
Order, Honorable Member Fonkana. Please, can we maintain order in the House? Why do you want to lose your temper over something? It's the law. There is no need to get upset. Just debate without being emotional. People are listening. There is a point of order. The Honorable Minister of Home Affairs and Internal Security. What's the point of order?
Madam Speaker, I know I'll have the right to reply. But the way he's debating, he's being abusive. He should debate in a manner of a civilized person. You are addressing me so that I can respond to the concerns. But you cannot be abusive. I know that is your nature. This is not Chamaiche, Madam Speaker. Is it in order to be abusive on the floor of this House instead of debating?
Order, honorable members. There is no need to lose emotions. The other day I was saying you can end up with high blood pressure for nothing. We have only one more day. Let's debate on issues and control our emotions. Order, honorable member for Lukasha. Please, honorable member for Lukasha, you've just come in and you're already debating while seated. I expect better from you. Thank you. So please, as you sit down next to your honorable member there, just try to cool him down. It's not the end of the world. These are just issues we are debating. So honorable members, as we debate, we continue to debate, to exchange ideas so that we can enrich the process that we are doing. So the honorable member of Nkana was out of order to lose his cool. So let's make progress. The honorable member for Shwangando.
Thank you so much, Madam Speaker, for allowing me to make some comments on the motion to adopt the reports of your committee, legal committee. Madam Speaker, I'll start by acknowledging the Minister for making this effort to finally bring this bill before the August House. Because I do recall that 7 years ago, I think he he as leader of opposition then did make a request to get this bill at this same stage of second reading to be deferred so that we could consider the Constitution. And so I've been itching to wait for him to finally deal with the bill, and here it is today. And so, Honorable Minister, this Public Order Act has been an emotive matter, but I think we need to, all of us collectively, apply to our wisdom so that we can settle these matters that have been problematic for many years. And I know that sitting where you are, you've got a mammoth task to ensure that, yes, people's liberties are protected, but also that there is order. So there's always been a conflict between order and freedom. And so the delicate act that is required to balance, to strike a balance between the two, is what has culminated into this bill. And therefore, we should utilize this opportunity to iron out some of the concerns that the public have raised. There is a concern regarding clause 2, and I'll just quote what the report is saying. The report is talking about the definition of public gathering under clause 2, which sets a low numerical threshold for what constitutes a public gathering. They submitted that defining a public gathering to include a few as 3 persons in a public place is unduly narrow and extends regulatory control to ordinary informal interactions that do not warrant statutory control. This is something that you need to take into account, Honorable Minister. When you say public place, it's a restaurant, it's a pub where people would gather, you know, for informal interactions. So if we are not going to narrow the numerical number of people gathering in a public place, it is certainly going to pose a very big challenge to your citizens, and more so to the enforcers of the law, because it's now the discretion of these officers to decide and say, oh, those people are meeting there, the 3 of them are politicians. Is it appropriate for them to gather? So narrowing that number certainly is not desirable, both for our citizens and indeed for the law enforcers. So this one, we may request that we consider an amendment, an appropriate amendment that can settle the anxieties of the people in this regard. The other one is the requirement under clause 8 for the approval of public gatherings by an authorized officer. They submitted that this requirement effectively converts the notification framework into a permit-based, which is inconsistent with the constitutional principles governing the right to freedom of assembly. Again here, it needs to be simplified, because progressively there is a mention that within 24 hours, an authorized officer should acknowledge receipt of the notification. Now, acknowledging of notification must be clear, because again, it is also saying that if they don't respond in 3 days, it would have deemed that a person wanting to convene a public gathering can go ahead. They would deem that non-response from the authorized officer means you can go ahead to do the gathering. Now, the catch is, you and I know how our law enforcement officers operate. In the absence of communication, and the person goes ahead to convene this gathering, and in their minds they think they want to cover themselves up by not getting back to this person who notified them, they would pounce on that gathering, and that culminates into something, because there's no clarity as to how that can be administered. The most important one also is this that involves us, who have been exempted, including you as minister. Now, the proposed section 3, clause 3, simply says exemptions for a person under subsection 2CD, which has talked about churches and all the internal meetings, cross-door meetings being exempted, and members of parliament, public workers holding functions. Here now it says, this exemption shall not apply during an election campaign, during an election, or where parliament is dissolved in accordance with the constitution. So if we leave it like this and not provide for what happens then, it will create a challenge. And I think I shared this with you at some point where I was saying here, it must be clearly stated that all these officers now, they have to revert to the Electoral Process Act, which then provides for the period of campaign and the schedules that are required in the campaign. Because when the Electoral Commission sets out the schedules for meetings, for example, you have got 17 wards. You have been given blocks on when you need to go into those wards. It doesn't mean then you have to go back to the police. So let that law kick in and let it be specified in this law so that the police do not find themselves in a challenge. So the other issue talking about appeals, Honorable Minister, you know how much the challenge that this is going to pose. Obviously, I know that in 2 days, 4 days, you will be also getting into campaigns to begin a new term in that constituency. There will be no minister in that office. So these appeals, we are talking about realistic things. So you need to understand we are helping you because we are talking about practicality. These are things that we have endured. So, Minister, let's provide for all these periods. And that's why I'm saying let's do the linkage between the enforcement of this law and the Electoral Process Act so that it's clear. The issue of appeals should have clarity in terms of how many days the appeals can be done to the hierarchy of the police before it gets to the minister's office. We know the bureaucracy that goes on in the structures of our Zambia Police Service. So it's important that we streamline and make clarity
your time is up.
to avoid future conflicts. So, Madam Speaker, I'm sure the Honourable Minister has taken note, and we expect that we can do with some amendments.
The list is long. And honourable members, an appeal that please let's not repeat on the same issue. As you come, discuss something new, add value. Honourable member from Pika.
Thank you so much, Madam Speaker, for this opportunity given to me to add the voice of the people that have been representing the past 5 years. Madam Speaker, like my other colleagues said, it's a sad day for all of us. And Madam Speaker, when we are making laws, we should make laws that will stand the test of time. I say so, Madam Speaker, because we've seen laws that are being passed that obviously take away the liberties of our people, such as the Cybersecurity Act, and today we are discussing this, the Public Gathering Bill. Madam Speaker, what is more concerning is the definition of the public gathering, which means an assembly, meeting or procession or demonstration of 3 or more people in a public place. The bill, Madam Speaker, defines a public place as any highway, marketplace, square, road, street, bridge, or other way which is lawfully used by the public, and any place, including a building to which the public are for the time being entitled or permitted to have access. Madam Speaker, the issue of 3 people requiring a notification to the police for them to gather is very concerning.
And, Madam Speaker, I hope the Honorable Minister will take a step to have this one amended. It has actually brought about a widespread discussion out there. Our people are wondering what kind of a country now we have, where 3 people will require to notify the police for them to gather. Madam Speaker, this, no doubt, takes away the freedom of our people. Madam Speaker, the other concerning issue is the issue of granting immunity to the authorized officers. Madam Speaker, we've seen how these authorized officers have abused the Public Order Act. Even despite so many court judgments regarding the application of the Public Order Act, these authorized officers have gone ahead to require them to give a permit for people to gather. So, Madam Speaker, they should have been left with no immunity so that they do not abuse this law, Madam Speaker, which will require our people to notify the authorized officers for them to gather. Madam Speaker, in the appeal case of the Law Association of Zambia versus the Attorney General, number 8, if I'm not mistaken, which was delivered in May 2016, the judgment clearly stated the supremacy of the Constitution, which confers liberties upon our people. Despite that, years that preceded, the police could not allow the people to gather. So, Madam Speaker, I suggest that maybe the authorized officers should not be granted immunity so that they are also able to account for their actions. Madam Speaker, as I conclude, I just want to make a passionate appeal to the Honorable Minister of Home Affairs, Madam Speaker, who has actually discovered a new constituency called Monze East, to ensure that the definition of the public gathering, Madam Speaker, is not of 3 or more people. It must be it must be well defined, Madam Speaker. Otherwise, it's very concerning, and our people out there are very much worried about this. Madam Speaker, thank you.
Thank you very much. The Honorable Member from Frida.
Thank you very much, Madam Speaker, for giving me this opportunity to add to this debate. And I'll be mindful, Madam Speaker, so that I do not repeat what the previous speakers have mentioned, which I totally agree with them. Madam Speaker, let me start by saying that this bill, if it is allowed to pass in its form, is a very bad law. It is going to be one of the worst laws passed by this government. Madam Speaker, the previous speakers have spoken about the definition of a public gathering, the threshold of 3. Madam Speaker, 71 years ago, I was long not born, 71 years ago, and that is how bad this law is going to be if it is allowed to pass, because it is taking us back 71 years ago. In 1955, Madam Speaker, when the colonialists wanted to stifle the activities of the nationalist movement in northern Rhodesia, came up with the Public Order Act, which limited the gathering. 3 people or more without a permit, kamata. And that is how it was so hard to fight for the independence of this country. And when the day of the independence came, it was the hope of every Zambian that laws like the Public Order Act, which the colonialists left, we will not go back to them. Madam Speaker, the Honorable Minister, the government are now taking us back to the 20th century. We are in the 21st century. Honorable Minister, listen to the debate on this bill in this House now, and take time to listen to what the public are commenting about this. A public place has been defined in so many ways, according to clause 2. 3 people found standing on a bridge may be arrested that they are gathering illegally. Madam Speaker, is this how we should live in the 21st century? Is this how we should live in the 21st century? Of course, there's been a lot of talk about the Public Order Act, and it is the hope that as we debate this, things like that should not even find space in this bill. Honorable Minister, don't take us back to 1955. We are in, what is this, 2026. It's shameful that the same things that the freedom fighters fought against, you are now bringing them back to the Bentens and the 2 pins to be complaining about. They were born free, and the freedom of association must not be tampered with. In fact, contrary to the objective that this bill is promoting the protection of the freedom of assembly, it is not. Madam Speaker, clause 8 of this bill says notify. The English I learned, Madam Speaker, when I notify someone, I'm just letting them know. I'm not seeking for their approval. Contrary to the minister's statement that this bill, in fact, is shifting from the permit-based system of managing public gatherings to a more friendly protection of liberties, it is contrary. It is not. How can clause 8 say you notify the authorizing officer? When I notify someone, I'm just telling them for their own information. And then clause 9 say wait for approval. It is inconsistent. This bill is containing clauses that are not speaking to each other. Do not disguise the reinstatement of permit-based system of managing public gatherings by introducing clauses like you notify the authorizing officer, and on the other side you say wait for the authorizing officer to approve. How do you wait for an approval? If you really want to introduce the issue of approvals, remove the word notify and say write for a permit. Apply for a permit and go and wait for 5 days. Then the authorizing officer will permit, will allow or not. But if you say notify, we all know. To notify is simply to say, on this day, I will be meeting this group and please be informed. But if you say notify and then you say wait for the permit, it is contradictory. Honorable Minister, don't take us back to 1955, I repeat. This country has moved through so many stages, so many governments, and it has been the cry that don't introduce colonial laws into a free country. Honorable Minister, as you consider bringing amendments, I'm sure you are listening, one of the amendments we should bring is to expand clause 9, clause 8 from this bill, expand it. This one which is saying approval of public gathering. If indeed we want to promote the protection of the freedom of assembly, people must not be waiting for a permit by a police officer to be allowed to gather. Madam Speaker, let me not repeat the other statements, but I just hope that the minister will take time. And his conscience must tell him we are in the 21st century. Don't take us back to 1955. I submit, Madam Speaker.
The Honourable Member for Chairman North.
Thank you, Madam Speaker, for according me this opportunity to say a few words on this bill. From the onset, Madam Speaker, I want to echo my friend's message that I'm a very sad man, that this bill now is reminding us about the negative effects of colonialism. It's very, very sad that 62 years after independence, our forefathers, Dr. Kenneth Kaunda, Ali Mwanga Nkumbula, and several others, fought against the 1955 Draconian Public Order Act. And it's sad that we can be, today, we can be reminded about those effects of colonialism. Madam Speaker, if Sir Roy Walenski today rose from his grave, I think he would be very much shocked that the same laws which we Africans were fighting against, they are the same laws which we want to continue to implement. This is very sad, Madam Speaker. The 1955 Public Order Act was meant to suffocate people's freedoms and also civil liberties.
All the honorable members, for us to have some direction. You've said about the opening remarks accepted, but please go to the bill. Make proposals on what you want to be improved or to be deleted, to be debate according to the. Let's not go back. That's why the Honorable Minister was saying it's being abusive, because the way you are debating, it's like it's him. Or maybe they don't want the Public Order Act to be amended. Maybe that's what it looks like. So please, let's stick on to the issues. Let's remain relevant. Let's not be abusive. You may proceed.
Madam Speaker, thank you for that guidance. Madam Speaker, this is a very, very important bill, and I think it's a fact that all the successive governments, from UNIP, MMD, PF, UPND, they have used this particular law to suffocate the opposition, which is very, very sad. So, contentious issues, Madam Speaker. One, I think the issue of I cannot repeat myself over the issue of 3 people assembling. I want to go to clause 4, where the bill is suggesting that there must be the police officers must be impartial in the way they are going to administer the Public Order Act. It is a fact that the police have been used by us politicians to use this law against the opposition and other interest groups. So for me, Madam Speaker, while we are saying that the police should be impartial, should be impartial, but again, clause 16 is offering them immunity. So we are giving and also taking away. So I feel that to consolidate this, these police officers who abuse the Public Order Act, I think they must be able to account. If it means being sued as individuals, that way it is going to promote professionalism in the administration of the Public Order Act. Madam Speaker, I go to clause, this is, clause 4, section 2, giving powers for an authorized officer to disperse a gathering if the meeting poses a direct or imminent threat to public order. Madam Speaker, this, I feel that it is open-ended and the police may abuse this. So I want to appeal to the ministry, to the minister, that I think they must look on this one, where police will just come up, even if when there's no peace which is going to be disturbed, they'll disperse the meetings. So this is subject for abuse. I go to clause 9, Madam Speaker, I think subsection 1. An authorized officer to restrict where a notice is deemed to have been received. Why should we again, why should the police officer be allowed again to restrict? So what will be happening is that when you make an application, they will not be able to respond to you. But immediately you assemble, they will go there and make sure that that meeting does not take place. So I feel that this particular clause must be refined. I think the issues of appeal, other debaters have said, instead of minister and the High Court, at least where a district police officer has failed to grant that authority, I think there must be a leeway to appeal to the provincial commissioner. We have a problem in other places, like in Chama today, Madam Speaker. A councillor can't hold a meeting from the opposition. Even myself, when I go in the constituency, I'm restricted. I'm told I must obtain a police permit. So this is the situation which, if we are not careful, people are going to abuse. So most of the time, I have to call the Eastern Province Commander, and I thank the commander, Commissioner for Eastern Province always intervenes. For how long is the commissioner going to be intervening? Just even these interviews for our aspiring candidates, they were denied. Until to call the commissioner, they said, no, you cannot have these interviews. Surely, Madam Speaker, we feel, I think, as a country, we can do better. The other issue is the issue of a person shall not be in possession of a firearm or a weapon at a public gathering. But there are people who have licensed guns. And this is just meant to protect in case of danger. I feel that this one also must be refined so that unless you abuse that firearm at a public gathering where there is no imminent danger, I think, yes, those people, you must be able to account. And on the offenses, if you are found guilty, 500,000 penalty units or imprisonment of a term not exceeding 5 years. I feel this is very punitive. The ministry must look into it. Today, murder, we have brought down the capital punishment, which is more punitive. Murder, you're killing someone, and just in possession of a firearm, we have not even discharged that firearm. So I feel that this penalty is very punitive, and I'm appealing to the minister that it must be looked into. So with these few remarks, Madam Speaker, I can only support this bill if these necessary amendments are being made. I thank you.
Thank you. The Honourable Member for Namwala.
Thank you so very much, Madam Speaker. Madam Speaker, the Public Gathering Bill is one of the most important bills, Madam Speaker, that was brought before this House. Before, when it was called Public Order Act, Madam Speaker, it was abused by those who superintended over our national affairs. It's very important to indicate that orderly, Madam Speaker, ought to be taken as number one for us to be able to execute duties on behalf of the citizens who gave us the authority to look after the affairs of this country. Let me be allowed, Madam Speaker, from the word go to support this bill. I'll support this bill because the contents are quite express. Express in the sense that, Madam, there's nothing that is implied. Anyone who understands or who led this bill would draw a distinction between law and moral. And when we're looking at issues from the legal angle, Madam Speaker, it requires me and you and everyone else to go through books, not just because of the way we lived, but what is contained and be able to interpret and execute it in the manner within the confines of what it dictates. That's one issue. The second issue, Madam Speaker, when you look at this bill, and whoever led it, will realize that there's great importance or promotion of constitutionalism. Not only that, Madam Speaker, it protects people's civil and political rights. And that's what is here. It was abused before. We had cases like Christine Murundika's, which were taken as precedents. But unfortunately, those that time who had power to superintend over our nations had no time to go in it and respect the contents of the Christine Murundika. Hence, the New Dawn government, Madam Speaker, bravely brought this bill here before the House for us to approve. And this is the bill, Madam Speaker, that will have no time to look at the ethnicity or the political affiliation for the people who are going to observe this right. And this is a right that ought to be respected. Zambia, Madam Speaker, have gone into a couple of covenants purely to look at issues of civil and political rights. And it's only then that those ones were domesticated and ought to be respected. But the question will be, were they respected before? The contrary is correct, absolutely not. But the New Dawn government, Madam Speaker, during the time when they were still in the opposition, they advocated that the bill shall be repealed. And this is exactly what we have seen. Without wasting people's time, this is a bill, Madam Speaker, that ought to be respected, to be actually taken the way it is, because all the contents are quite express, and these are the contents that do not have time to look at the issue of discrimination. The people of Zambia will be allowed to observe their rights within, unlike the way it was. And are we okay with it? The correct thing is yes, Madam Speaker, people of this republic ought to enjoy their freedoms of assembly, freedoms of associations, freedom of movement, Madam Speaker, not forgetting the freedom that actually happens when people meet, which is freedom of expression. Madam Speaker, it's worth noting that when we go to look at issues of such nature, we need to go beyond our nails so that we know exactly what we are debating for. With these few words, Madam Speaker, I thank and stand ready to support this bill. I thank you.
Thank you. The Honorable Member for Kanyama.
Thank you, Madam Speaker, for this opportunity. Madam Speaker, I just want to echo one of the concerns that our colleagues have raised. Madam Speaker, one of them is the issue of notice. Madam Speaker, I think there's an issue that we tend to ignore. We are all well aware that the police's role is to provide, peace, order, things to be done in an orderly manner. Now, here's the situation, Madam Speaker, where at will, maybe 4 or 5 groupings want to gather here in Lusaka for whatever reasons. And bearing in mind that should anything wrong happen, we will still rush to the police and report those happenings. So when you talk about notice, you're just giving a notice to people, the police, so that they are able to prepare or to be alert in event something, which shouldn't have happened, take place. Here's a situation where people go somewhere, gather, then from there some unruly people, like we used to have previously, with the Kadarism. Unruly people will just stand up and go and disperse that, and people are beaten here and there. Then where do you run to go and report? And we should bear in mind that where someone's rights ends, the other person's rights start. So those who are gathering, they have got a right to freedom of, they need to be protected. So if these people that would gather at a particular place without notifying the police, someone comes, attacks them, or rush to the police. So we are merely giving notice to the police so that they can prepare for that event and to provide protection or security to those people who are gathering. Madam Speaker, the authority officer would want to prepare his team, gather or assemble his team, so that those that have gathered will be able to conduct their business without being disturbed. There was an issue, Madam Speaker, where someone referred to the Constitution of saying people, because of the freedom that emanates from the Constitution, freedom of expression, assembly. Madam Speaker, there is no society like the society that we are living in where rules take precedence that should not be regulated. Anything that happens should be regulated. So to have a society without order, Madam Speaker, I don't know how that society would live. So the issue of abusing, for me, I would call it abusing these freedoms or rights that are in the Constitution, where someone just want to stand up and do whatever he wants to do. That is the abuse at its highest level. Madam Speaker, this bill does not at any time bar anyone to have a gathering. It provides that you give a notice, and if there's no response, Madam Speaker, that notice will be deemed to have been received. And on that particular day that you proposed to have that gathering, you can go ahead. So I don't see where this law is trying to bar anyone from going ahead with the intended gathering. So, Madam Speaker, just to to iron out on the concerns that, a number of people have. Madam Speaker, this is a good bill in a sense that it provides security or protection to those who are gathering. At the same time, it protects those who could be somewhere nearer. An example is, say, for instance, someone goes to conduct some gathering at a primary school where there are children. So, of course, there is need for people, those children that are there, to be protected. They are not part of that gathering. So now, if we just allow anyone just to go and do whatever he wants to do, Madam Speaker, some unruly people will just go there, beat all the children, then at the end of the day, who do we blame? We'll push the blame to the police for not having protected those people. And once you are asked as to why you went ahead to conduct such a gathering somewhere, and you have caused the search, then you want to say, no, I'm being victimized because I've been stopped from conducting such gatherings. So, Madam Speaker, this is one of the perfect bills that I've come across since I came into this House. Madam Speaker, with these few remarks, I submit.
Thank you very much. The Honorable Minister of Home Affairs and Internal Security, winding up debate.
Madam Speaker, I'm extremely shocked that my colleagues can make such comments pertaining to this bill. And what they are telling me is that I must withdraw this bill and continue with the Public Order Act. I'll be happy. I'll be happy, Madam Speaker, to go ahead and withdraw the bill so that we continue with the Public Order Act. That's what you're telling me. Madam Speaker, this particular bill was not crafted by government. It was crafted by stakeholders. More than 100 stakeholder organizations sat and crafted this particular bill. We even had a ceremony, Madam Speaker, accepting this particular bill from stakeholders. The stakeholders, they had to balance the security of the nation and the rights of individuals in this country. Madam Speaker, this particular bill, I am shocked to hear that they are condemning that we are exempting the right to hold meetings by those in government during elections. Yet those are the complaints they have been raising, that those in government have an advantage of holding rallies during elections without notifying the police. We are now telling the nation that we all require to notify the police. They are saying no. We should allow those in government to continue holding meetings without notifying. Because of the way they have been behaving, Madam Speaker, they want to be carrying pangas in meetings, during meetings, to be carrying guns. That's what we are hearing. As long as you are not firing, we should be allowed to be carrying guns in public. I've never heard such an irresponsible statement, Madam Speaker. We have all been saying we need peace in this country, but they want us to be carrying guns. When going for meetings, we should be carrying machine guns and pangas. I'm shocked. Madam Speaker, we members of Parliament have been complaining that they have been restricted from meeting their electorate. But now we are being told, no, this bill is bad because we have allowed you to do that. Madam Speaker, according to Section 6, it requires the one notifying to indicate the purpose of the meeting, the number of people who will be attending that meeting. The policeman has the right to know who is holding the meeting, what is the purpose of that meeting? What if the notice, if we don't check, what if the notice, Madam Speaker, is saying that they are going to burn buildings after they meet? Should we just allow people to do such things? We will be irresponsible. We will be responsible. We have a duty to protect this country. We don't want anarchy in this country. This bill has been accepted by people of Zambia. They are the ones who crafted this bill. They are the ones who crafted this bill. Madam Speaker, this bill has given responsibility of duty on the part of officers. There is no longer impunity for police officers. There are sanctions under this law for a supervising officer to derogate. You don't want us to introduce a new law. You want the Public Order Act currently in force to continue. That's what you're telling me. That's what you're telling me. You are telling me that I'm taking you back to the colonial era through this. What about the Public Order Act? Where has it taken you? Because it's in place now. We can use it. And you know the consequences of the Public Order Act. We have given you liberty. We have told you, we are giving you authority to meet in your party secretariats without notifying the police. You don't want that. You don't want that. You are condemning this. It's because some of you have not read. You have never read. Satan will never appreciate Jesus. That is the way you are behaving. That's the way you are behaving. We are the only party government. We are the only government who have been courageous. We are the only ones who have been courageous to bring an act which is not favoring us. Madam Speaker, we are the only government that has been courageous enough to repeal the Public Order Act. This Public Order Act, the Public Gatherings Bill, does not favor us. It doesn't. Can you tell me a provision which favors me? There's none. 3 people is currently in the current law. It's in the law now. The law which we want. I can withdraw this one and continue with the current. What are you going to gain?
Honorable members.
What are you going to gain? Madam
Honorable
Speaker,
member for Bangweru.
Madam Speaker, Madam Speaker, I know political mischievousness. They want us to withdraw this bill so that they can go out and say the UPND government has not passed the Public Order Act, the new Public Gatherings Act. We made a commitment to the people of Zambia that we shall pass this law, and we are passing this law today. If you are aggrieved, you know what to do. If you think there is a provision that violates the Constitution, go to court. This bill is for the people of Zambia. This bill was crafted by stakeholders, not those who are no interest of the nation at heart. What I've heard today has shocked me. I'm aware, Madam Speaker, their representatives, PF, were members of this committee that crafted this. They are the ones who crafted this bill. All what we have done, Madam Speaker, is to ensure that it conforms with the legal drafting. That is all. The content is yours. You were represented. You were represented. Madam Speaker, if there will be any amendments, genuine amendments, we shall do so. But as far as I'm concerned, there are just emotions, fear of losing elections, and appealing to members of the public for support. You will not make us withdraw this bill.
Thank you.
We are now presenting it. Madam Speaker, I thank you.
Thank you very much. Thank you. Can we have some order, please? Have we already started gathering? Order, honorable members, let's make progress. I put the question. The question is, honorable members, let's ensure that we behave with dignity in the House. How can somebody say which question? When I said I put the question, somebody says which question? Eh? Order. I put the question. The question is that the bill be now read a second time. As many as are of that opinion say aye. Of the contrary say no. The ayes have it. The ayes have it. The question is resolved in the affirmative. Let the bill be read a second time.
The Public Gathering Bill, National Assembly Bill number 71 of 2026.
Committee stage to be taken when?
Tomorrow, Madam Speaker.
Committee stage to be taken tomorrow, 12th May 2026. Next order.
The Petroleum Development and Management Bill, National Assembly Bill number 72 of 2026, second reading.
The Honorable Acting Minister of Energy.
Madam Speaker, I beg to move that the bill be now read a second time.
The question is that the bill be now read a second time. Any debate? The Honorable Minister of Energy.
Madam Speaker, I wish to thank you for according me this opportunity to submit a policy statement on the Petroleum Development and Management Bill 2026. This bill is a critical legislative instrument aimed at strengthening the governance and regulation of the petroleum sector. It is anchored in the Ministry's mandate to develop and manage energy resources in a sustainable manner so as to enhance the sector's contribution to sustainable socio-economic development for the benefit of the people of Zambia. The bill seeks to address long-standing structural and institutional challenges in the sector, provide a modern, responsive, and forward-looking legal framework in the management of the importation, transportation, and storage of petroleum products, as well as establish the uniform petroleum pricing mechanism. Madam Speaker, the Petroleum Development and Management Bill...
Order, Honorable Minister. I suspend business for 20 minutes for a health break. So we come back at 2020. I'm sure somewhere you find something to eat.
Still watching Parliament TV, the station that is dedicated to bringing Parliament closer to you. Business has been suspended for 20 minutes. Business is expected to continue at 2020. At the time business was being suspended, the House was considering the Petroleum Development and Management Bill, National Assembly Bill number 72 of 2026. And on the floor of the House is the Honourable Minister just giving a policy statement.
And other business is still to be considered on the floor of the House includes the Technical Education, Vocational and Entrepreneurship Training Amendment Bill, National Assembly Bill number 73 of 2026, to be considered at second reading stage. We still have the Penal Code Amendment Bill, National Assembly Bill number 74 of 2026, to be considered at second reading stage, and the Local Government Amendment Bill, National Assembly Bill number 75 of 2026, to be considered at second reading, and also the National Assembly Speaker's Retirement Benefits, National Assembly Bill number 77, to be considered at the second reading stage. And we still have 21 more bills to be considered at a committee stage and 2 bills to be considered at report stage. So this is business yet to come when the House resumes at 2020 hours. For now, we take a short break.